While studying law, certain section of a particular act looks very easy. But when you really start discussing the section, then you feel like, yeah, it is little bit tricky. One such section is section 25 of Evidence Act, which discusses about confession to police officer not to be proved. At the outset, it looks so easy, but is it really easy? Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of Evidence Act, we were discussing the part 2, which is all about relevancy of facts covered from section 5 to 55, and in that series we were discussing confession covering from section 24 to 30. We have already understood the meaning of confession, different types. We have covered section 24 also, and here in this video I am going to cover section 25, which discusses about confession to police officer not to be proved. Looks very easy. Is it really easy? Let's try see in my 3-slide video. Section 25 says, no confession made to a police officer shall be proved as against a person accused of any offense. Now, if an accused make any confession in front of a police officer, that cannot be considered as confession, or it will not be proved as confession. Now, there is one simple difference we need to observe between section 25 and 26 is, under 26 we are discussing about police custody, whereas under section 25 it can be anywhere. That is the only thing you need to remember. Here there is no mention of any specific place. I hope that is very clear. Now, if you look at the section, it looks very easy. But here the issue is with the term police officer. Who is a police officer? Before even getting there, let us try understand why do we need section 25? Why the confession made in front of a police officer is not considered as a confession? Because if we start considering the confession made in front of the police officer as a confession and start proving the guilty, then police can go to any extent to ensure that such accused has confessed. They can torture such accused, or they can extort, they can create fear, they can use force. By using all such techniques, a police officer can make an accused to confess that he has committed such crime. That is why it is not considered as confession, so that we can avoid torture, extortion, fear, force, etc. from a police officer to the accused. Now, why is this so important? Because this is one of the fundamental right. This has direct connection to Article 20 of Indian Constitution, which discusses about protection in respect of conviction for offences, where subclause 3 of Article 20 says, no person accused of any offence shall be compelled to be a witness against himself. While that is about confession, the very important question that arises out of section 25 is, who is a police officer? Believe me, there is no single definition available in any of the acts in India on the term police officer. Legislation has to make one. Till then, we will see a lot of interpretations, and I have a lengthy list of such case laws where the term police officer is discussed. The next slide is completely dedicated on those designations which are considered as police officer, and I have also listed few of the important case laws. Before going anywhere, let us try understand the term police officer with section 2O of Criminal Procedure Code. While it is not directly discussing about police officer, it discusses about officer in charge of a police station. So we can make a connect here. It says officer in charge of a police station includes when the officer in charge of the police station is absent from the station house or unable from illness or other cause to perform his duties, the police officer present at the station house, who is next in rank to such officer and is above the rank of constable, or when the state government so directs, any other police officer so present. Though this is not exactly defining the term police officer, this is defining something close to the police officer. We have Police Act 1861, and unfortunately there also we don't see the definition on the term police officer. When there are no definition available, what does law do or what does courts do? They start interpreting, and on the term police officer also there are lot of interpretations available, and by Supreme Court based on several cases there are interpretation on the term police officer. In a nutshell, we can say that the police officer in section 25U is wider than the term in section 1 of the Police Act. Supreme Court says a police officer means an officer other than a magistrate whose duty is to prevent and detect crime, the later duty involving the duty of holding investigation. In other words, a person holding powers for effective prevention and detection of crime to maintain law and order. The two important things that we need to observe from this particular aspect is the police officer both prevents and detects crime, and he has the power to conduct investigation. This is being discussed under several sections of CRPC also, and that is what Supreme Court has to say. But before Supreme Court has to say that, there are many other case laws are also available which have given an idea that who are all covered under police officer, which is a big list I have in my next slide. As said, based on lot of case laws and interpretations, below are considered as police officers. Here the list is not exhaustive. That means there can be other positions also which are considered under police officer. The people who are considered as police officers can be Assistant Superintendent of Police, Deputy Commissioner of Police, Police Constable, Police Chowkidar, Village Chowkidar, Guard, Home Guard, Central Reserve Police Force, Civil Guard on duty, Special Officer or Inspector, Ward Rationing Officer, Sub-Inspector of Police, Sub-Inspector on deputation, Security Inspector in a corporation, etc. And one very important observation is they may be in uniform or they may not be in uniform. That is okay. Few important case laws are Nanu Sheikh Ahmad versus Emperor, Radha Kishan Marwari versus Emperor, Amin Sharif versus Emperor, State of Punjab versus Barkhat Ram. These are the few case laws you can refer from where this term police officer is developed. And one of the important statement by Subbarao J was in the case law State of Punjab versus Barkhat Ram, where he said, I may observe upon the provision relating to them that section 25U, 26 and 27 were transferred to the Evidence Act verbatim, that means exact or precise from the Code of Criminal Procedure 1861. They differ widely from the law of England and were inserted in the Act of 1861 in order to prevent the practice of torture by the police for the purpose of extracting confessions from persons in their custody. He tried to give both the perception on the meaning of police officer, which he thinks is directly taken from CRPC. On the other hand, he is also trying to say that why this section is very important, or why confession made in front of police officer should not consider, because he says otherwise police will start doing torture to extract confessions. That is what we need to learn from this particular statement. With that, I am taking you to case laws. The first case law that I am referring here is Aru Bhuyan versus State of Assam. Here in this case law, it was held that confession is a very weak kind of evidence. It further says that in India, it is common among police that they use third degree treatment or method to extract confession from the accused, and court needs to be very cautious while accepting the confessions made in front of police, because maybe accused got tensed or scared so that he confessed in front of the police, and court should not accept it as is. That is what held here. Saying so, it also said that under section 25U of Evidence Act, anyhow, the confession made in front of the police is irrelevant. But on the other hand, if there are any confession made under section 15 of Terrorist and Disruptive Activities Prevention Act 1987 or the TADA, now there the confession made in front of the police officer is relevant, and that also need to be observed. That is all discussed in this particular case law. Then comes the landmark case law, that is R versus Huribole. Now this is one of the most important case law as far as section 25U is concerned, where there were two important things held. One, the confession made in front of police officer should not be straight away considered by the court. On the other hand, it also said that the term police officer should be read not in any strict technical sense, but according to its more comprehensive and popular meaning. That means we should not put a frame to the term police officer and read it. We need to look at it in a wider sense. That is what held in this particular case law. The third case law discusses in alignment to section 173 of Criminal Procedure Code, where the police officer got the power to prepare charge sheet. Whereas in this case law, that is Baduku Jyoti Sawant versus State of Mysore, it was held that Central Excise Officer cannot be considered as police officer because he doesn't have power to prepare charge sheet as under section 173 of CRPC. That is what held here. That way, there are many case laws where few are considered in the group of police officer and few are left out from the definition of police officer. That's my time on section 25U, and in my next class I will be discussing section 26. There is a small difference between section 25U and 26. Here we are discussing about the confession made to the police officer. There is no reference of the place here, whereas in my next session when we are discussing about section 26, there we are discussing about the confession made to the police officer in custody. That is the difference that we are going to discuss in my next class. Till then, thank you so much for subscribing my channel. Please like, share and comment my videos. All the very best for whatsoever purpose you are watching my channel, and thanks again.